case, can we start with the program?
Yes. I think we should start. It's 11:05. Just let me go live on the YouTube. All right. Yes, we are live.
I hope you don't mind if my this pic will go on.
No worries, ma'am. No worries.
Okay.
It's a nice pic. Very good morning to one and all. Thank you so much for joining today. My name is Ameya Agrawal. I'm the founder of SkillSlate Foundation. And today I welcome all the participants who have joined us on the Zoom platform as well as the YouTube platform. Some of you are not able to join because of some prior schedules, but don't worry, we will be sharing the recordings. And today we are having an exciting resource person who has vast experience about this IPR patents and all. So I think it is very important that you guys stick through the workshop. It is going to be around 4 to 5 hours of workshop combined, day 1 and day 2, followed by question answers will be there. And I think this cohort, a lot of participants are joining from rural areas, rural colleges, as well as top tier 1, tier 2, and tier 3 cities as well. So this cohort is going to play an important role in helping you understand about the entire IPR process, patents, internal discussions. So this is a good opportunity for you all. Honorable Vice Chancellor of CU at Central University of Haryana will also be joining us and addressing and guiding us. So please, I request you all to take a notebook, a pen, and make sure that you record or read or write each and every important thing which our resource person and our guest of honors are going to be speaking today, because trust me, this time, this current period is a period for India in the technology or in the patent or in the copyright section, because a lot of innovation has been coming from India, and it is very important that you secure your patents or copyrights on it, because these kind of innovations which are going to happen now are going to become redundant soon, because technology and everything is changing so fast each day. So it is very important that before anyone copies it or before anyone uses it for their purpose, you understand all the process and you secure your rights, because these rights can also help you to make it commercial. It can also become a integral part of your business, entrepreneurship, and whatsoever. So please make sure that you stick by till the end of the workshop to ask any questions. We won't be taking the questions mid-program. All the question answers will be happening at the end of the program. All right. And those who are joining from YouTube, dear participants, I request you to please drop your questions towards the end in the chat box, and we will take the questions from there. If anyone is yet to join from your community or college, please ask them to join fast, because otherwise they will miss on important topics in the beginning. To take the program forward, I really thank the Central University of Haryana for having us for this program, having SkillSlate for this program, and organizing this wonderful program, because we have associated in the past with Central University, and it was always been a great experience, the kind of audience and the kind of purpose which they work. So thank you so much, Central University of Haryana, and thank you so much, Sunita ma'am. I hand over to you to please introduce about our today's session, our speakers and guest of honors, and take our audience forward on this journey of learning about IPR. Over to you, Sunita ma'am. Thanks a lot.
Thank you, Ameya Agrawal sir. It's actually always been wonderful to work with you. I have gone through some of the workshops organized by you and the international conferences also. And I'm very happy to collaborate with you for this event also. Today we are here to organize a 2 days national workshop on IPR, patents and copyrights. Taking care of the present scenario, we are all much aware with the fact that this is one of the very important topic and the most sought topic as well, because a lot of environment has been created for entrepreneurship, innovation and all. And taking care of that, IPR, patent and copyright becomes a very important topic of discussion. So I'm very thankful to our supporting team, because Central University of Haryana is organizing this 2 days national workshop in collaboration with SkillSlate Foundation. Before starting with the program, I just want to give you a view about the program. that it is a 2 days national workshop in which in length things will be discussed on IPR, patents and copyright. And it will go for 2 hours on 5th of March, and for 2 hours it's on 6th of March. Now, the schedule, before starting with the process, I just want to welcome Professor Srivastav Madam, Professor Sunita Srivastav Madam, the convener, Center for Innovation and Incubation, Central University of Haryana. Central University of Haryana, that you know, it's one of the 15 new central universities established under the Ministry of Human Resource Development in 2009. We have a 488 acres of campus in Jat Pali, Mahendragarh, with presently working with 72 academic programs in UG, PG, and research. It is one of the NAC accredited university. And CUH is moving ahead, keeping the goal of all-around development of students at the center. The university is engaged in research, innovation, skill development, as well as developing opportunities for employment generation. The university is striving to develop necessary modern facilities for the student in the field of higher education. In the direction of successful implementation of National Education Policy 2020, the university is moving ahead in a planned manner and for skill development and employment generation of the students. The university is working at the micro level through special training and placement centers. CUH is moving towards realizing the dream of self-reliant India, Saksham Bharat and Strong India, as shown by the Prime Minister Narendra Modi. And Professor Sunita Srivastav, the convener, Center for Innovation and Entrepreneurship. I, Dr. Sunita Tanwar, coordinator, Center for Entrepreneurship, and the coordinator of program, me and one of my colleagues, Professor Nishant Singh. We are here working day night on the same target under the direction of Professor Sunita Srivastav. I just want to brief you about Madam. Professor Sunita Srivastav, she is a professor in Department of Engineering, Center for, just a minute. Professor Sunita Srivastav, she is convener, Center for Innovation and Incubation, Central University of Haryana, heading the Department of Engineering and Applied Sciences. She is a member.
Well, I think it is fine, Dr. Sunita. I'm professor in the Department of Physics and Astrophysics, and I'm also looking after Center for Innovation and Incubation of Central University of Haryana.
So glad to have you, ma'am. I welcome you on behalf of all our coordination, Central University and SkillSlate. I request you to please address our audience and guide them about this.
Yes, let me start with what I want to convey. A very good morning to everyone, and we welcome our Chief Patron, Honorable Vice Chancellors of Central University of Haryana, Professor Tankeshwar Kumarji, and distinguished resource person, Dr. Jayashree A. Bangali, who is industry expert and trainer, and also head electronic department. She is also coordinator IQAC and from Kaveri College of Arts, Science and Commerce, Pune. And I also welcome all our eminent faculty members who have joined. I can see Dean of Academic Affairs, Professor Dinesh Kumarji, and other eminent faculty members, esteemed guests, and dear students. On behalf of our organizing team, comprising of Dr. Sunita Tanwar, who is Coordinator Entrepreneurship Cell, Mr. Nishant Singh from Printing Technology Department, and also Mr. Ameya Agrawal ji from SkillSlate Foundation and Zovy Studios. I warmly welcome you all. In fact, we are all aware that intellectual property right is a very intangible asset of any institution. In fact, it gives you a competitive edge in a market and protects from hackers and pirates. So because our country is very fast growing economy and innovation is becoming priority for Indians and our government also, this innovation needs protections, and also for this intellectual property, it is very essential to protect, as it is very critical to foster innovation. So this is very important. That because I am also looking after this particular center for innovation and incubation at our university, and a lot of things are mushrooming out day in and day out, because now it is offline mode and students are coming in groups, in fact, at the center and doing a lot of things. So we are actually very happy and very nice that this workshop has been organized. And we are all aware that if we do not protect our intellectual property, we cannot enjoy the full benefits of our innovations. And hence, we would focus less on research and development. In fact, this intellectual property right are the rights which is exclusively given to person over the creation. So it is for the students who are attending this workshop that they must know the importance of what we are doing today. So in fact, it's exclusive right which is given to the person over the creation of one's mind for a certain period of time. So it also gives an innovative protection against any competitor who illegally contravenes in the creation. Okay. So when a startup patents its innovation, its value rises and financial perspectives also expand. So moreover, investors are more likely to acquire a startup which processes well-protected IPRs. So this is because it forms a greater resource while you are competing with industry, which is a very giant sector with increase in importance of this intellectual property. Instances of IP crimes have become the part and parcel of this digitized era, which may even lead to failure of business. And usually the companies which try to promote this commercially, the products, they rely on adequate protection of their patents, trademarks, and copyrights. While the customers also, they make use of this intellectual property to ensure that they purchase whatever they purchase, the goods are good, assured of quality. So an IP acts as an asset. It is like any other physical property which offers commercial benefits to its business. And in fact, today's world is a web-based world. So it becomes all the more relevant to have IP protection, because it is comparatively more simpler than ever to reproduce any specific, say, template or logo or even functionality. So if we have strong IP laws, it gives protection to the intellectual property and contribute to the economy of a particular country. So it is one of the sources of security for intangible properties, which are still open to the public and which can be, quickly replicated by anyone. In fact, अगर हमको IP rights मिल जाते हैं, तो it fosters confidence in us and ease of mind also that consumers demand and markets rely on. So it's very important to understand that whenever we talk about innovative ideas, it basically means to earn profit ideas, and they have little worth on their own. So इसको बहुत जरूरी है पेटेंट कराना, and it has great untapped potential to turn innovation into product and services which can be taken at a commercial level later. So registering of copyright and patent, it will always result in a constant stream of fee and increased income also, and that will boost the overall market result. So one must evaluate the market needs and situation to determine which intellectual property right, चाहे वो trademark हो, चाहे copyright हो, चाहे patent registration हो, it should be used to cover various areas of intellectual property. So also we realize that if we want long-term social and economic development of our society, so countries, they need to strike a perfect balance on how to secure the intellectual property rights of any individual or even the companies, and it should be neither too strict nor it should be too lenient. So with this background or introduction, you may say, this is what we are looking for in this two-day workshop, and we have a big expert in this area, Dr. Jayashree A. Bengali. So we are very fortunate, madam, and we welcome you. And I think everybody are going to benefit to a large scale in these 2 days workshop. So
Thank you.
It has been really, really wonderful. So thank you, and I also, congratulate all the organizing team, the entire organizing team, and of course all the participants. Thank you.
Thank you, ma'am. Thank you, Professor Srivastav, for explaining the importance of IPR, copyright, and patenting. No one can better explain it other than you, being a person from physics and astrophysics. In fact, ma'am has a lot of achievement, but she has not given me a time to see all those things. She has a very good.
No.
She has more than 109 research paper in Scopus level journals and more than 590 citation with an H index of 14 and I-10 index of 23. So I think she is only one out of maybe all of us that who can better explain the importance of this copyright. And being a convener of an entrepreneurship, being a convener of innovation and incubation, she is the one who is taking lead in our university to moving all the innovations in that direction. And definitely in coming time, we'll come up with a lot many number of patents. Thank you, ma'am. So now I would like to introduce Chief Patron, Honorable Vice Chancellor, Sir, Professor Tankeshwar Kumar, who is not only a leading force, but a light direction to all of us for moving in this direction. And from the time he has joined this university, he is the one who is promoting this self-reliant India concept, promoting the activities of innovation, entrepreneurship, and under his guidance and direction only, we are excelling and we are trying our level best. So Professor Tankeshwar Kumar, he is a Vice Chancellor, Present Vice Chancellor of Central University of Haryana. And prior to this, he has worked as a Vice Chancellor of Jambeshwar University of Science and Technology, Hisar. And an additional task also he has taken in Dinbandhu Choturam University. He's
Hello, ma'am. I think your voice is not audible. Smita, ma'am.
Sorry. I'll just repeat the things. Honorable Vice Chancellor, sir, is a lightning force for all of us, who is motivating us to move in this direction. And under his flagship only, the Entrepreneurship and Center for Innovation and Incubation is flourishing in the Central University of Haryana. And recently, our university has gone through 4 days of program on wonders of science, which was conducted in our university, dealing with all sort of new ideas, startup, and other science-related activities. So, Honorable Vice Chancellor, he is the present Vice Chancellor in Central University of Haryana, and prior to that, he served as a Vice Chancellor, GJU Hisar. Prior to that, he has served a VC additional charge of Dinbandhu Choturam University. Professor Tankeshwar has 35 years of experience, including teaching, research, and administration. He has a good number of research publication in international and national journal of repute. And he has got an H index of 22 and I-10 index of 40. His research area is theoretical and computational condensed matter and nanotechnology. Sir is first UGC professor in India in FRP. He has guided 13 PhD research scholar. He is fellow of International Academy of Physical Sciences and member of National Academy of Sciences, Allahabad. He is editorial board member of a number of international journals and World Condensed Metaphysics. He has been a member of Senate and Syndicate of Punjab University.
Hello. Ma'am, you are not audible.
Sorry once again if there is some technical error because of which I'm not audible. But I just want to say that Honorable Vice Chancellor sir has a lot of achievement in terms of publication as a VC. Third term he is doing taking care of a VC charge, and he is the person of a lot of energy, dynamism, and leadership under whose guidance this university innovation entrepreneurship cell is growing, and definitely in coming time we'll come up with some good number of achievements. He has been awarded associateship of ICTP Italy in 1997 to 2004. He has been research leader ICTP Italy from July 1993 to August. He has visited abroad at least 17 times to different countries of Europe, Africa, and America. He has been awarded with Golden AIM Most Dedicated Vice Chancellor's Award, Vidya Sagar Award in 2017, Lifetime Achievement Award in 2016, Appreciation Award by Federation of Corrugated Box of Manufacture in 2016, Education Leadership Award in 2016, and Ibish Award of Amity University in 2015. He has been associated with various social organizations like Bharat Vikas Parisad, Shikshan Mandal, Vigyan Bharati, Seva Bharati, Swadeshi Jagran Manch, and many more. And he is the first Vice Chancellor to implement NEP 2020. So with this, I would like to request Honorable Vice Chancellor, sir, for his address to the gathering. So.
Sunita ma'am, can you please check if there is any technical issue from sir's side?
I see.
Yeah. If you can just call him.
Yeah, ma'am.
Guys, in the meantime, Honorable Vice Chancellor sir joins. Let me quickly take this opportunity to talk in short about SkillSlate Foundation and why we are doing this particular workshop, or why we do any kind of workshops in which you guys all have been part since many years now, around 2 years you guys are participating in our workshop, and why we are doing this particular cause. So SkillSlate Foundation is actually a non-profit organization which we started around 2 years back. It was started with the motive to make education skills and opportunities accessible to all. And with support of you all guys, we were able to impact and train more than 25,000 people, not only across India, but also from neighboring countries such as Bangladesh, Sri Lanka, and even the people from UK, US has also joined most of our programs. So it has been a wonderful journey since the last 2 years. And our community include many vice chancellors, honorable vice chancellors, deans, directors, industry persons, professors, students, and many entrepreneurs as well. So it has been a very collaborative community, and community with diverse background, which was able to uh, pull these things, because during the pandemic we realized that it is not possible for everyone, though online education makes everything accessible, it is not possible for everyone to access that accessibility. So that was the issue. We want to make the accessibility accessible, and that's why we built this particular platform. And we have been fortunate to be collaborating with many big names and industries across the India, and reach even the remotest areas of India. And today we are glad that we are able to empower and power the many colleges and universities from the rural section, who were not actually aware of these kind of programs, or who didn't know where to start, where to begin, but they are now collaborating, and they are actively involving their students and faculty members to join these programs and learn from this. That's why we keep 90% of our programs free of charge, so everyone can take benefit of it. And I hope that after this program also, we are going to take part and join on more such programs, and many colleges and universities are going to come forward, because we do have signed MOUs with many universities as well to provide such kind of programs for their students. And I'm sure that all the members who are here today from the administration, or be it the training placement office or the students, they are on this path to learn new things, and it is going to be a great journey ahead. So that is in short about the SkillSlate Foundation. I won't say much because you guys are already with us for many years now, and it's a protocol I follow to make sure I introduce us, because it gets in the video. Ma'am, has sir joined, Sunita ma'am?
Sir, actually, sir is in a meeting, so he'll join the moment he is free. And
Okay.
before we will he will join. I think we need to start with the things. So
Yes,
before we start with something, I would like to give an introduction of Mr. Ameya Agrawal, who is an engineer turned into a social entrepreneur. He is the founder of SkillSlate Foundation, a non-profit organization working to make education, skills, and opportunities accessible to all, and is also the CEO and development director of Mahatma Gandhi Seva Sangh, an NGO with over 2 decades of experience in working for the rehabilitation of persons with disabilities and promoting accessibility. Ameya is also a national record-holding author of the book A Leap Within, a book on self-motivation, speaker, and founder of Zovy Studios, a corporate supply company that deals in gifting, merchandising, and event management solution. Other than all of his efforts which are visible, and I would like to request Ameya Agrawal sir for the introduction of speaker, Dr. Jayashree Bangali. Ameya sir.
thank you so much, ma'am, for the nice introduction. And this wouldn't have been possible without you, of course. You have been a great hand in making this possible, and all the workshops we have conducted together. I would like to introduce our resource person today, Dr. Jayashree Bangali, ma'am, and SkillSlate share a close relation. We have been working for many months now together, and it has been always a pleasure to work with ma'am under her expertise. She is the head of electronics department and a coordinator at Kaveri College of Arts, Science and Commerce, Pune, and has more than 21 years of experience and 4 years of industrial experience in electronics. And she has also done her PhD from the Pune University, and has been a guiding, she is one of the, I think, most in demand trainers on IPR. We have been receiving multiple requests on having ma'am for sessions on IPR, because the way she conducts this program are so fluent and are so flawless that from students to industry experts, she somehow manages to cater to all of the participants in a single webinar. So that is a great, and we are really glad and grateful to have Jayashree Bengali ma'am today for this particular workshop, as she has published more than 40 research papers in national and international journals, and have to USA, Malaysia, Singapore, Nepal, and have published 29 electronic textbook through Nirali Prakashan, which is one of the very popular publishers in Maharashtra for many kinds of be it engineering books or be it books related to technology. And she has received the Dr. Sarojini Naidu International Award for Working Women in September 2021, and has also received the Best Teacher Award in Applied Sciences by Global Society and Basic Applied Sciences, Mumbai. She also received the Best Teacher Award and a Sincerity Award at Kaveri College from Kannada Sangha Pune, and her profile related to IPR, patents, and though she also has the credential, but the experience also which she has working with the students, working with the professionals is very extensive. So I request all the participants today to please take the opportunity. I will say exploit this opportunity and get to learn as much as possible from ma'am, because she has been helping not only students, but she has also helped many budding entrepreneurs and founders in their IPR, patent, and copyright processes. And as Srivastava ma'am says, once you have a patent, it adds credibility to your product. It adds credibility to you as a founder, as a teacher, or as a researcher, and it does open a vast opportunities for you in the market. So please, it's a humble request to everyone. Please take full benefit and utilization of this workshop, because these kind of workshops are only for you, and only because of your determination of participants like you, we are able to convince very busy Jayashree Bengali ma'am to give her precious time for us today. So I hand over to Jayashree ma'am to take the session forward, and please guide our very enthusiastic participants. Thank you so much, ma'am. Over to you.
Thank you so much, Mr. Ameya, for such a wonderful introduction. And thank you so much. And first of all, good morning to one and all, respected VC sir, Srivastava madam, Tanwar madam, Ameya Agrawal sir, and all the professor I can see in the actually participants. So there are many professors, they have joined from various subjects. They are working in various departments, and also I can see students in the participants. So good morning to one and all, and thank you so much for inviting me and giving me the opportunity to share my knowledge with you all. Thank you so much. So first of all, I just would like to brief that in these 2 days, so we will talk about the IPR, then patents, then copyrights, then registration processes, then its importance. And as the many students have joined this workshop, so at the end, maybe last session of 6 March, that is tomorrow, I will just brief about the career opportunities in IPR. So can I share my screen?
Yes, ma'am, you may share.
Okay. So let me share my.
Also, I actually forgot. Please let me just quickly share the distribution of our audience today. So it can
yes, please.
The participants, because the kind of response we have got.
Yeah.
50% is the distribution, ma'am. 50% are students, and 50% are teachers, HODs, principals, vice principals, self-employed people, and entrepreneurs. So I think this is a great distribution, because we are able to cater to all the kinds of people today, and I'm sure all of them will be learning great things. Thank you so much, ma'am. Over to you.
Okay, thank you so much for briefing about the audience, because it matters a lot. Because presentation, I will just turn around according to the participant, because students are there, teachers are there, professors are there, head of the departments are there. So today I will conduct 2 sessions. I have separated out the, you can say, parts of IPR. And accordingly, I have designed the session because after one session, we can have a short question answer session, and then we will go for the second session. So today I will conduct two sessions. First session will be of IPR, then their types and the information regarding the allied international treaties. So it is very important to know what are the actual terms which are used in the IPR field, and also what do you mean by treaty, and what are the different treaties India has signed, and all this information. So I will talk all these things in the first session. Then we will have a short question answer based on this. And in the second session, entirely I will talk on the patent and the Patent Act 1970. So each and everything about the patent I will talk in the second session of today's program. So let me share my screen just a second. Is it visible to you, sir? Is it visible, sir? Ameya, sir?
Hello, yes, ma'am.
Okay, fine. Thank you. So today we will discuss about the IPR, what is exactly meant by IPR, then their types and the allied international treaties. So this is very important part of the IPR. So my presentation outline for the first session will be introduction of to intellectual property, then their types, then their its importance, then IPR and allied international treaty, and then we will go for the concluding remarks. So maybe students and teachers, HODs who have joined the session, they may be aware about all these things, but I wanted to start from the basics, because I don't want to lose any point regarding the IP, and as most of the students are listening the session, so we will start from the property. So we usually know that what is the property. It's a position of an individual or a group, and there are two basic properties. First one is the tangible property, and second one is the intangible property. So we all know about the tangible property, because we are actually having our property in the form of maybe from the chair to land to flat to bungalow. So the physical property which has the property which has the physical parameters, it belongs to the tangible property. But now we are interested to know about the intangible property. So this intangible property is not physically present actually. So it is in the form of the human intellect. So many of you must know about this, but this intellectual property is the basic type of intangible property which don't have any physical parameters. So this WIPO is the basically World Intellectual Property Organization. We will talk about this WIPO also in the latter portion of this session. So according to this, the definition of the IP is that it refers to the creation of the mind, such as invention, literally artistic work, design, symbol, names, images used everywhere. Okay, so all these things belongs to intellectual property. Now, what are the intellectual property right now? Today, IPR is a buzzword, and it is people are known to IPR word. So what is it basically? It's a legal rights conferred on intellectual property. They are known as a intellectual property rights. In short, they are known as a IPR. Now, just in 5 minutes, I would like to brief about what when the people have realized that we should have such IPRs. Because in the 18th century, before this 1873, just people are have the exhibitions, and they are keeping their products in the exhibition, and they are introducing in the market. But in 1873, actually, in the international exhibition, which was held in the Vienna, so some of the industrialists, they realized that their ideas would be stolen, and people can misuse it, and they can have the production of these ideas. So at that time, people have realized that something should be there, some legal rights or legal in the form of law. There should be something which will protect our inventions, our ideas, our creations. So from that point, actually, people have realized, and then countries have started forming the laws for this IP. So what are the important reasons behind is that once the IPR is formed in the particular country, then it provides the intensive to the individual, to the creator, to the inventor. Then also it gives the accord to recognition. Recognition is very, very important, and also financial benefits. So these financial benefits are also important. And the last point is also important because very genuine and original products, inventions, they are available to the society. So that's why people have realized that there is a need of framing this intellectual property rights in the form of law, in the form of act. And then the journey of this IPR was actually started. So IPR mainly deals with the rights, creation of those things, and its enforcement. Then this question maybe in your mind, that where this IP can be created. So actually it can be created in colleges, schools, university, or you can say it anywhere by any inventor you can create this IP. Only the thing is that you have to protect your IP. That is most important. So again, just in 2-3 minutes, I will brief about the history. So in the before we can say that this World War II, so all the countries are engaged in the World War II, and then US actually formed new country alliances, and then it will actually US took a role of superpower, and they frame first this IPR. So as they frame their intellectual property rights and laws, then other countries follow them, and then each country have actually framed this IPRs. So this WIPO I have just now mentioned, it's a World Intellectual Property Organization. It was actually it is a global forum for IP, and which provides the services, policy, information, and it gives the guideline to all the countries, and it is a self-funding agency of United States, and 193 members today they have, and its headquarter is at Switzerland. So all these WIPO, then WTO, then Paris Convention, and Bonn Convention, we will talk about the latter part of this session. What about India now? The history of IPR in India is that in 1856, actually, Patent Act was introduced, and it was remained in force for 50 years. And then in 1911, it was amended, and it is called as the Indian Patent and Design Act. And after independence, actually in 1970, the act was again amended, and it was called as the Patent Act 1970. Today also, we are actually following this Patent Act 1970, which was amended many times from this 1970. So this is about what do you mean by IP? What are the different terms associated with the IP? What is the need of it? And what is the history of IPR? So moving ahead with the types of intellectual property rights. Now, I will take it briefly because many of you from the audience, you are quite aware about this, but I will just technically explain it, because we know the terms, but we can't maybe relate these terms. So that's why I will brief about the types of this intellectual property. Now, IPR can be broadly classified into two categories, basically. First one is the industrial property, and other one is the copyright. So in the industrial property, invention or patents, trademarks, industrial designs, and geographical indication, which is known as a GI. So these types comes under the industrial property. And under copyright, literally an artistic work such as novels, poems, then film, musical work, artistic work, all these things comes under the copyright. So these actually 8 other different types of intellectual property rights. So biological diversity is not exactly the type of IPR, but we usually include this biological diversity in the types of IPR. So now in brief, we will see all these types. The important types are the first 4, that is patent, copyright, trademark, and industrial design. But we will briefly discuss about all the 8 topics. So first one is the patent. So you must have known to this that it's a basically patent were one of the first types of intellectual property rights, and now everybody quite familiar with this word patent, and everywhere we are using the patented product, I can say. So from the morning, so the toothbrush which are using, toothpaste which are using in the morning, it is also patented, till the good night which we use at the night. So all these products are patented, and there are millions of patents actually registered in the world. So what it gives the exclusive right to the owner. So this exclusive word is very, very important. So some of the people in the last session, actually I have conducted through, I think, SkillSlate only. So one of the participants have asked me that these rights are also called as a negative rights. So I have answered this that yes, it can be actually called as a negative right, because it gives the exclusive right to the owner. So other cannot use it. So to use that invention, they have to take the permission of that inventor or owner or creator. So in that sense, if you think, then yes, it can be called as a negative right. But it is actually not, because we have to give some credit, some financial benefit to the owner, to the creator, to the inventor, isn't it? So a patent gives exclusive rights to the owner, and it excludes others from making, using, selling, offering that invention. So this is very, very important. The second type is a trademark. Now you have aware about this. There are millions of trademarks we are observing today, and it is actually a sign or logo which distinguishes the goods or services of one enterprise from the other enterprise. So it is actually helping the company to get the recognition, to get the reputation in the market, and from the sign or logo we can identify, yeah, this is the company. So this comes under the Trade and Merchandise Market Acts 1958, and its tenure is 10 years. After that we can renew it. So you can see actually very few I have listed on the PPT, but there are millions of trademarks now are registered. And today also many people are going for the registration of this IP. So these are the famous trademarks. So just by signing, we can identify that yes, it's a Nike. So when Federer wears just a band on his head, having this sign, then yes, we can identify that it's a Nike. So this is just a recognition of that company, and other cannot use it because it is a registered trademark. So all other trademarks you can see on the PPT. The next type of the IP is a geographical indication, which is also very, very important, because if we don't register under this GI, then other people can register it, other countries can register it, and they can enjoy the financial benefit of it. So I will give you the example of this in the latter part of this session. So what is the GI basically? It's actually certain agricultural products have special qualities which are influenced by the geographical climate or soil. So we know that some of the maybe Alfonso mango from the Konkan area, or maybe the oranges from the Nagpur. So they have a particular test. So that test belongs to the geographical climate of that region, of that area. So this is belongs to the GI. And if that is registered, then other cannot claim it. So in India, GI can be registered under the Act 1999. And the duration of GI is also 10 years. Renewal is required after 10 years. So these are the very famous GIs. You can just see Tirupati Balaji Laddu, then Rasgulle, then Halad, then Silk, then Darjeeling tea, then this Basmati rice, Kurg oranges, then Alfonso mango, Kolhapuri chappal. Recently in Pune, we have got a GI for Puneri Pagdi also, which is very famous. So all these are the examples of GI. Going ahead to the industrial design. Now, once I give you the example, you will understand what is this industrial design. So according to WIPO, it is design can comprise of ornament or aesthetic aspect. So it can be in the form of 2D, that is 2-dimensional, or 3-dimensional. So its actually tenure is again 10 years. Now here you can just see the example of this industrial design. So here you can just see that this bottle is actually the bottle of the Coca-Cola. So the shape of this bottle is registered. Then this shape of this sandal, it's a design, actually it's a design. So this is a register under Industrial Design Act. Then the design of this Nike shoes, then this design of this ornament, then this guitar, bicycle, chair, all these designs, all, if you just observe it carefully, all the things are in 2D or 3D. Okay, so all these are registered under the Industrial Design Act. And also there are millions of designs, they are registered. Moving ahead, another type of the intellectual property is a trade secret. Now it is very, very interesting, because once you go in the depth of all these IPRs, you will understand the negative points of patents, and also the positive points of the trade secret. Because see, a trade secret means what? As the name suggests, it's a secret. We are keeping something secret. We are not opening it. We are not publicizing it anywhere. We are keeping it as a secret. So why people are keeping this as a secret? The main reason is that actually some of the companies, they want to keep their ideas as a confidential information. They don't want to publicize it, or they don't want to file its patent. Now, once in this next session, after this session, in the Patent and Patent Act, I will explain this in detail. But just now, I try to understand that if you are going to file the patent, then you have to disclose your invention. That is the first condition. In the registration process of the patent, in the second step only, you have to disclose your invention. That invention is publicly available on the IP India site. Anybody can read it, and also anybody can raise the opposition for it. So some of the companies, they don't want to actually go for the patent because they don't want to disclose that information. That is the main reason, and they go for the trade secret. So they want to keep their idea, their invention as a confidential information. Okay, so this is actually one of the important type of the IP. So technological information or process, maybe recipe, idea, software, formula, maps, or any commercial information, the company can, or maybe the owner can keep it as a trade secret. So here you can just see the examples of it. It is quite interesting to know that Coca-Cola recipe is under actually trade secret. I think it is invented in the 18th century, and from that day till today, they have not patented it, or they have not publicized anything related to recipe of Coca-Cola. They have kept it as a trade secret. Then another example is a Google algorithm. So it's a basically search engines. Now everybody is on the Google, and whatever we have any question, we just type on the Google, and we most of the time we got the correct answer or nearby answer. So it's a basically search engine, but its algorithm is a trade secret because they have not patented it. They have not registered anywhere. Then processes that Intel use, if some of the faculties or students are from the electronics or maybe the physics, they are quite familiar with the microprocessor chips. So Pentium microprocessor chip or other chips that Intel has invented. So they have actually kept it as a trade secret. Then, as I said, Coca-Cola from 1886, actually, they have kept the recipe of this as a trade secret. So it is quite interesting that they have actually framed some policies for that. That's why they are successful in keeping the recipe secret till today. So from 1886 till today, so they are quite successful in keeping it secret. So because they have framed the policy accordingly. So these are the famous example. KFC chicken recipe is also one of the trade secret. So the another important type of intellectual property is copyright. This is also very important because copyright protects the rights of creator. So it is basically refers to the right to copy. So once a particular literary or artistic work is registered under the copyright, others cannot use it. So copyright basically protects the expression of an idea. It cannot protect the idea. If you want to protect the idea, then you have to go for the patents. Okay, so copyright basically protects the expression of an idea and not the content of idea. So this is also very important. So all these things tomorrow, in the tomorrow session, we will discuss about this copyright, its registration process, then some of the challenges of the act also. So tomorrow we will discuss this. So all these things comes under the copyright, computer programs, then motion pictures, artistic work, musical work, they will comes under the copyright. Then according to the act, the duration is 60 years after the death of the author. So it is a quite long duration act has given. So the another type of IP is the plant varieties and farmers' right. So people have realized that whatever invention they are doing in the farms, that should be protected. So some of the professor or students are from the biology, then they will understand this, that farmers are doing something with their farms and they are inventing the plant varieties, and somewhere it should be protected. So under this IPR, they can protect it. Basically, it is for the protection of the plant breeders. So again, it's a tenure is 15 years. Then protection of integrated circuit, which is popularly known as IC. So you might be aware about this, that just now I have mentioned that Intel has actually taken the patent of this Pentium processor. So Pentium processor, it's basically a microprocessor. And under this integrated circuit layout, they can register. And the mobile phones, actually, today we are using the mobile phones, which are quite advanced in the technology. And all the companies, they are having their own processor. So Samsung, maybe iPhone, or maybe Motorola, they are having their own processor, and that is protected under the integrated circuit layout design. Then biological diversity, it is basically related to the genetic material of actual or potential value. So it is actually the functional unit of the hereditary. So Ayurveda knowledge was one of the best example of this, is comes under the traditional knowledge actually. This is not actually the type of IPR, but I have just included it to give the information to it. So these are the types of IPR, and the important types of IPR today we are quite familiar is the patent, copyright, industrial design, and the fourth one is the GI. So all these are quite familiar with all the people, and now people are actually understood the importance of protecting their intellectual property right, and many people are now coming forward to register their IP. So this is a very good sign actually. But in just 4 or 5 slides, we will have the discussion of the importance of this IPR. So this is a very old actually example. It's a world's first instant noodle, which was actually made in Rhodes, because they wanted to actually create some noodles which can be easily eaten anywhere with just a ball and chopsticks. So they have invented this noodles which named as a chicken ramen in 1958, and they took a patent of it, and then it turned out a big hit because other people tried to copy it. Then this company have filed the infringement cases against them, and they won it, and they enjoy its really financial benefit of it. So it is very, very important to protect your IP. And then this is the another example. Actually, many examples are there, because in maybe before 5, 10, or 15 years, this IPR is not popularized, and many people are not known to this IPR, maybe in the 2001 or maybe 2004. So this is one of the famous case study in the case of this field, in the field of IPR. It's a Darjeeling tea. So we are very well known to this Darjeeling tea. It's the first GI of India, we can say. So actually this Darjeeling, we know that total production of it is 846 million kg. So 31% of the world's favorite hot drink. But to take the GI of this, we have to struggle a lot, because the other foreign countries, they have started using the name of this Darjeeling. They are actually selling the tea by using this Darjeeling tea, and many things happened actually. though we have the tea board, which was set up in the 1953, and we export this Darjeeling to various countries, starting from Japan, Russia, US, UK to Netherlands, France, Germany. But still, if you just see the case study of this, it is means from the case study, you will understand that it is very difficult actually to get the GI of this, and this tea board of Darjeeling, they have to struggle a lot to get this GI. So we filed the GI in 2003, and we got its GI status in India in 2003, but it is only in India, not in the foreign countries. So in the European Union, we got it in the October 2011. And that's why it is very, very important that being the Indian, and whatever is the special qualities of the soil, of the maybe area, we have to protect it and we have to register it. So Tea Board of India has faced a series of hurdles and challenges and difficulties in protecting this Darjeeling tea. So this is very famous example in the field of IPR. This example, if you just remember, it's a turmeric. So Mashelkar sir, if you just remember, they actually struggled for this, and they have raised the objection of this because in 1996, one of the foreign country, they have actually taken a GI of this turmeric, and they said that it is very good to heal any wound. So after that, when the Indian have raised the opposition, then the WIPO, they have cancelled the registration of this turmeric. So we have to be very alert in this field of IPR. And again, we have to struggle to get the GI of this. We got this GI in the 2019, actually. It's Odisha. So Erod turmeric, we got the GI for this. Then many IPRs in one product you can have. So as I said, this Coca-Cola is very, very famous drink in India or in world, I can say. And all the things of this product, it is protected. So starting, as I said, industrial design. So the shape of the bottle, starting from the shape of the bottle, recipe, then trademark, then whatever content which are there on the bottle, everything is protected. So no one can copy it. And that's why the recipe is a trade secret. So Pepsi, if you just drink Pepsi and Coca-Cola, the tastes are totally different. Then this is another example. It's a CD player. So you can just see the how many components they are having, and it is protected under some of the IPR. So maybe it's an industrial design protection for 3D shape. It may be for the music which are played on the CD player. It is also protected. Then various technical parts. All these are protected. Now I can just give you the example of our mobile. So the camera which is used in our mobile, starting from camera to sensors to processor, or then touch screens, all the things it is protected under the IPR. So the camera and maybe the sensors which are used in the Samsung mobile, they are not the same in the Motorola, or they are not same in the iPhone, because each mobile company, they are having their own components, and they are actually protected under the IPR. So this is about the types of IPR. Briefly, I have tried to explain all the types of the IPR, and hope that you have understood all the types. So if you have any question, I can wait for 2 minutes, or otherwise I will go ahead. Shall I go ahead? Yeah, so Erod turmeric of Tamil Nadu, maybe type of Odisha. Yeah. Yeah, it is from the Tamil Nadu. Yeah, correct. Yeah. IPR is an invention or innovation. One of the Monu Rajak is asking. So invention and innovation. When I explain this in the patent session, in the next session, I will explain it in detail. But invention and innovation, what is the difference between the invention and innovation? Is nothing but invention means it's a new thing, isn't it? Invention is something new, and innovation means what? Again, it is something new, something novel. Okay, so to get a patent, actually there are 3 conditions. So I will just explain this condition in the next session. Please explain about the copyright. Yes, tomorrow we are having the special session on copyright. Entire session will be on the copyright, tomorrow's first session. So I will explain all the things related to copyrights. Can you explain trade secrets again, ma'am? Okay, trade secrets is actually nothing but, I have already explained this, is it's a confidential information. Means once you understand the conditions to filing the patent, you will understand the importance of trade secret. As I mentioned that if you want to go for patent, you have to disclose your invention, isn't it? Disclose your invention means what? You have to publicize it, and that publication will be on the IP India site. So IP India will, once you file the patent application, it will publicize on the IP India site. Anyone can go through it and anyone can raise opposition also. But some of the people, they don't want to disclose their invention, then they will go for the trade secret. Yes, yes. Yes, I can share my PPT, doesn't matter. In the research, if you use the CR work, then it's a, okay. In tomorrow's session, actually, I will explain all the things related with the copyright. Okay, so shall I go ahead now? Ingredients of any medicine is a trade secret. See, it depends on the company. It depends on the company. If a company has taken the or filed the patent of it, then after 20 years, I will just explain this in the next session, actually, in good way. Dr. Ishwar Singh, about the pharmaceutical company, I will explain in the next session. Okay, shall I go ahead now? Okay, fine, thank you. So just in brief, I will explain this. I am not going to explain the Ipr Acts because Patent Act I will explain in the next session, and Copyright Act I will explain in tomorrow's session. So allied international treaties we will see. Just a minute. Okay, so these are the famous IPR Acts which we are following in India. So Copyright Act 1957, then Patent Act 1970. Then trademarks under Trade and Merchandise Marks Act 1958, and design under Design Act 1911. So these are the important acts that we are following in India. So I just wanted to explain this, the meaning of this treaty, and also what are the different treaties that India has signed, and what are the benefits we are getting after signing this treaty. So that we will see. So these are the few, some of the people pronounce that it's a treaty, or some of the people pronounce it a treaty. So treaty and treaty is one of the same, it's a difference in the pronunciation. So TRIPS, PCT, Paris or Paris Convention, Budapest Treaty, and Bern Convention. These are the important treaty that India has signed, and we are now getting the benefit of it. Now, what do you mean by basically this treaty? So it is basically a written agreement. Okay, agreement is at the international level. Once we sign that agreement, then we became the member of that treaty, and then whatever terms and condition mentioned in the agreement, we have to follow these terms and condition, being a member of that treaty. So in a simple way, I have explained it. So actually this treaty is nothing but it's an international agreement between the states, between the countries rather, and which have, or which govern by the international law. And once we, being an Indian, or India has signed a particular treaty, then they have to follow the terms and conditions which are mentioned in that agreement. So it is a simple definition of this. Names, convention, maybe agreement, maybe pacts, maybe general act. So just now I have just said that Paris Convention. So Paris Convention is nothing but it's a treaty. So it refers to the creation of the written agreement. So it is very, very important to know that what are the different famous. I'm not talking about all the treaties. I am just talking about the treaties which are related to the maybe the patent, may be related to the copyright. So this TRIPS, that is trade related aspects of intellectual property rights, this is very, very important treaty, and actually they have formed main goal or main objective of this agreement is that they wanted to set some of the international rules which reduce the distortion or which promote the effective and advocate promotion of IPR. So this is a very, very important treaty, and we have signed this TRIPS agreement. Then WTO, that is the World Trade Organization. This is another important term in the field of IPR. First, we have said that WIPO, that is World Intellectual Property Organization. This is WTO, that is World Trade Organization. So it is also an agreement on trade-related aspect, means TRIPS, and it is the most comprehensive multilateral agreement on IP. It came into force in 1st January 1995, and also India has signed this. Now, why this? They have means at international level, why they have thought that we should have this TRIPS. Now, today we are actually going through a very critical time. There is a war in between the Ukraine and Russia is going on. NATO and all these things, you have heard these words. So a member of NATO, member of this, and being the member of this, they are not protecting or they are not supporting to any country. So all these news we are hearing now. So similar to this, if you have the member of this TRIPS or if you have the member of PCT or Paris Convention, then you have to follow that terms and condition. And then other countries also, they should have also follow the condition. So why this TRIP basically they have actually invented is that they wanted to actually frame some international law which will be efficient enforcement provisions, which will have efficient enforcement provision, and it is against counterfeiting and piracy. So that's why this TRIPS agreement actually came into the force, and in 1995. And it basically sets the standards for the protection of all types of IP. So it is actually it's an agreement, as I said, it's a written agreement, and it is very, very vast. So it's not the this time that we will discuss on this. We will just understood that we have signed, being India, we have signed this TRIPS agreement, and now we are also getting the benefit of it. The another important treaty is the PCT and Paris Convention. This is also important because see, once you file the patent application in Indian Patent Office, and if the Indian Patent Office grant the patent to the owner, then that invention is protected in the India only. But if any inventor wants to have the protection for his invention in the foreign countries, then he or she should go for the PCT application. Okay, so in the next session, I will explain this, what is PCT application. But this Paris Convention is very important because once you file the international patent application through PCT, then whatever 192 countries, they have signed this Paris Convention treaty, then in all these countries, that invention gets protection. So this is very, very important. And because see, in only getting the protection for the invention in India is not sufficient, isn't it? So in the foreign countries also, that invention should be protected. So that's why PCT or Paris Convention is important. Then Paris Convention is for the industrial property, and it was adopted in 1883 actually. The details of this I have actually mentioned. So one of the important thing which I have put it in the red color, that is important. Once you file the international patent application using this PCT in Indian Patent Office, and if the patent is granted to the inventor, then if it is a PCT application, then in all 192 countries, that invention will get the protection. Okay, so that is the important thing. And the date of the application means, suppose today I will file the application and I got the patent maybe after 2 years or 3 years, because it's a very long process. So whenever the patent is granted, but that grant is from the date of application, is means what, from today the patent is granted to the inventor. So actually, I have given or mentioned rather that many people, this IDMA, that is Indian Drug Farm Manufacturer Association, the pharmaceutical actually companies, they have opposed to it, but despite of their lobby also, India became the member of this PCT. Then this is another important thing. The teachers, students who are from the biology, they will understand this, the importance of this Budapest Treaty. It's basically when you are filing the patent application, you are actually disclosing the invention, its method, its best method in the application itself. Okay, but if it is related to the biological invention, if it is related to the microorganism, then in the written format, it is not possible to publicize the invention, isn't it? So that microorganism should be, what I can say, it should be stored somewhere. It should be deposited somewhere who will look after this microorganism. So in that case, this Budapest Treaty is important. So this is the International Depository Authority. It is at the international level, and the inventor can get its actually invention. So as I mentioned, disclosure of the invention is a requirement of the grant of patent. So this microorganism, it is not possible to disclose it in the written description. So they have to deposit somewhere, and that depository is provided by this treaty. So all these things are related to the food and pharmaceutical fields. As I mentioned, those who belongs to biological subject, they will understand the importance of this. So this treaty basically makes the patent system, what I can say, in foreign countries also, some of the patents, if you want to protect, then you should go through this treaty, because all the whatever countries they have signed this treaty, the protection will be given to the invention in all those countries. So that's why this treaty is very, very important. Then again, this is for the industrial property. Then this Bern Convention is another important thing, because Paris Convention, PCT, all these are related to the patents. But this Bern Convention is related to the copyright. It's a protection of literary and artistic work. So if you want to protect your literary or artistic work in foreign countries, then it should be Bern Convention treaty. So if the applicant have filed the copyright through this treaty, then he will get the protection for this literary and artistic work in all the foreign countries who have signed this treaty. Okay, so this Bern Convention adopted in 1886 actually, and it gives the rights to their author. So this is the important things, that India has become the member of Bern Convention in 1928 and Paris Convention in 1998. So now we are the member of all these TRIPS, Paris Convention, Bern Convention. We are member of all this treaty, and that's why whatever GI, maybe patent, maybe copyright, all this filed in India, if filed through international application, then all this invention can get the protection in all the foreign countries. So today there are more than 25 international treaty framed by this WIPO, and most of the treaties India has signed. So this is about the international treaty. Because why I have included this in the first presentation, because whatever I am going to talk in the maybe second session or maybe in the tomorrow's session, you will understand it in the better way once you know the different treaties, the meaning of it, and the importance of it. That's why I have included in the first presentation itself. So coming to the end of the first session, so we have discussed the intellectual property rights, their types, then its importance, and also we have discussed about the international treaties. So I would like to take questions if you have any. Okay, if you have any questions, I would like to take, and then within 5 minutes we can start with the patent and patent act session. Thank you so much for your patient listening. Ameya sir? If you have any questions, you can unmute yourself or you can just type in the chat box also. Both ways are fine for me.
Yes, any questions? Questions from the participants?
Students, don't get hesitate to ask the questions. Okay. Ameya sir.
Hello. Yes. Guys, if you want to ask your question directly, please raise your hand. There is an option to raise hand. I will unmute you and allow you to share your video as well. Please raise your hand if you want to ask question, or you can ask in the chat box as well. Ma'am, one is asking, please tell about logo patent.
Logo patent. Actually, logo cannot be patented. It can be registered under the trademark. Logo cannot be patented. Sign or logo, you can go for the registration of the trademark.
All right.
Okay, explain TRIPS once again. So TRIPS is actually it's one of the important agreement. It's a multilateral agreement, and it's a very vast actually. Few slides actually I have just a minute. I have taken it actually fast. So if you just want to, yeah. So basically this TRIPS is nothing but it includes the standards for the protection of all types of IP. So why they have actually designed this TRIPS is because there is no standard enforcement, then provision for the dispute settlement, and also for the traditional and institutional arrangements. So as I said, each country, if you just see the IPR, that is intellectual property rights, or maybe the IP Acts or laws, each country will have their own laws. So each country have designed their own laws. But at international level, actually, there are no standard laws available for all the countries. That's why they have designed the TRIPS actually. So it includes the standard of enforcement, then provision of dispute settlements, and also it gives the clarification about the piracy or maybe the infringement. So all these things are mentioned in the TRIPS. Agreement between different countries are TRIPS or not? Yes, it's an agreement, and many countries have signed this, and once we sign this, we have to follow the rules and regulation of it, as I said. So it's actually designed to have the common or standard rules for all the countries. That's why it is designed, because the main challenge of this IPR Act is that each country have their own laws. That is the main challenge of this IPR. And it is very difficult to match with the other country. Is there any compulsory to give? Related to trade secret registration, the trade secret information to no, whatever you can have the trade secret, but in the trade secret, whatever information, it may be recipe or it may be any other thing, then that is not disclosed. It is kept secret with the company itself. Only registration under the trade secret, but that recipe or that information or that process, that is kept secret. They don't have to disclose it anywhere. Is the fee for international, just a minute. No, we have to check about this fees. I will just describe this in the tomorrow session about copyright. Ma'am, how can we differentiate between patent with trademark? And yeah, actually see, patent means what? Now in the coming session, I will just explain that if you want to register for the patent or if you want to file a patent application, what are the minimum conditions that should be fulfilled? Okay, so patent is, first of all, it should be new, it should be novel, it should be useful, and it should be non-obvious. These three conditions should be fulfilled by the invention. Okay, then only patent is granted to the inventor. Trademark is totally different. Trademark is a sign or logo. It is nothing do with the idea, because idea or invention can be patented. Sign or logo cannot be patented. Then you have to go for the trademark. And industrial design, it is for the 2D or 3D, that is two-dimensional or three-dimensional things. So these three are totally different actually. Yeah, actually both both these conventions are different for the developing countries and for the developed countries. So in tomorrow's session, I will just talk about this, why it is so. Anyone question? Any other question?
As you can now also talk directly to ma'am. I have unmuted you all if required.
Yeah, they are putting it in the chat box, sir. So I am going through it. Many questions are there actually. I have answered many of them. Yeah. Shall I go ahead with the patent? Ameya, sir?
Yes, ma'am. Yes. Yes.
Okay. Just a minute. Huh?
You all are free to ask the questions directly from the speaker.
Jaisha ma'am, you can continue with the next session.
Yes,
Now
yes.
we will take more questions.
Yeah. Is it visible to my screen is visible, sir?
Yes, yes, yes.
Yeah, yeah. So we have discussed about the definition of IP, then the types, its importance, then international treaties, all the basic things which are related to the IPR that we have discussed in the first session. So now we will go to the second session. So in this, actually, we talked about the patent and the Patent Act 1970. So everything related to patent we will discuss in this, including the filing procedure. So this will be the presentation outline. So first we will, I will introduce the patent, then act, then types of patent application, because if anybody interested from the audience to file the patent application, he or she should know it, then getting patents in India and abroad, and then we will go for the concluding remarks. So as I just now, I have shown this slide in the first presentation also. Patent gives the exclusive right to the owner, and others cannot use it, means use that invention, sell that invention, make production of that invention without the permission of the author. So this is the patent law actually. And so it's a Patent Act 1970. So if you just see the first condition in the patent application is that you have to disclose the invention. Okay, so who can file the patent application? Yes, inventor can file, assignee of the inventor can file, or maybe any legal lawyer, they can file the patent application, and the patent application should be filed in the patent office, Indian Patent Office. So now this is very important, that what can be patented and what is not allowed for the patented. So this is related with the Patent Act. So if you just go through the Patent Act 1970, it has 169 sections. And again, in 169 section, each section have the subsections, that is A, B, C, D, E, F maybe, or A, B, C, D, like that. So it is a very vast act, and legal language is used in the act, obviously, but I have tried to simplify it, and I have just included the information that is related to the patent or filing the patent rather. Okay, so first part is what can be patented, because this is the first question. So any process or product that offers a new way of doing something or new technical solution to a problem, that can be patented. So the invention, or one question in the first session, some of the student or maybe faculty have raised that invention or innovation. So that invention should be new, that is the first condition. It should be novel, it should be useful, and it should be non-obvious. Now we will see what these three terms meant by. Now first is to be novel. So an invention must be different from anything else. That should be not available publicly. That is the first condition, first and very important condition. So public knowledge means what actually? Public knowledge means it includes anything. Anything means it. Some of the invention can be suppose published in the form of the research paper, or maybe in the article in newspaper, or maybe in some of the published in some of the sites, anywhere. So the first condition is that the invention should be different and it should be not publicly available. Okay, so that is the first condition. Then it should be non-obvious. Non-obvious means what? Now I will give you one example. Suppose I am the person from the electronics field and I have suppose design a particular system, and then it is suppose a microcontroller based system, and the person from my field, for that person it must not be easily perceived. Means the person, expert person from my field, my electronics field, that invention should not be easily perceived. That is the meaning of non-obvious. So this is also the second condition, and I will give you the summary or maybe the scenario of this. Many patents have actually rejected on this condition because it was not non-obvious. So this is the second. And third one is also important, that it should have an industrial application. It should be useful. That is the main condition. It should be useful. So these three conditions, if satisfied by the invention, then only the patent is granted to the inventor. So these are the main basic conditions. Then the another part is that what is not patentable or what is not allowed to patent. So section 3 of this Indian Patent Act 1970, this it says that invention which is laughing, which is playful, that is not allowed. Related to atomic energy, that is also not allowed. Then invention based on traditional knowledge. So in the last session, some of the participants, they have asked that this Ayurveda, I have just now given you the example that the knowledge related to maybe yoga or maybe Ayurveda, is it possible to have the patent of it? But it is not actually, because it comes under the traditional knowledge. Then invention which are contrary to natural laws, which is injurious to human health, so that is not allowed according to the section 3. Then any process of medical or surgical, means suppose any doctor is doing some operation, the method of that operation, then that cannot be patented. Then literally dramatical, musical, artistic work is not patentable. It can copyright it. Okay. Then a computer program is also not patentable. You can take its copyright. Okay. Then presentation of information, topography of integrated circuits, all these things are not allowed according to the law. So you cannot have the patent of this. Then these are the, as I said, these are the subsections of the Patent Act. So the machine which is having the more than 100% performance. So you know that practically it is not possible. You cannot give the more than 100% performance. So that is not allowed. Then gambling machines, then the device for housebreaking, all these things are not allowed. Then this 3D section is very, very important. I will explain this why it is important, because it stops evergreening. Now, what do you mean by this evergreening is pharmaceutical companies actually, the patent duration is 20 years. So suppose one of the pharmaceutical company, for example, suppose we have taken the Combiflam or maybe Saridon tablet. If they have taken the patent of this, then after 20 years, because maximum duration of the patent grant is 20 years. So after 20 years, that is available publicly. So what this pharmaceutical company usually does is they just have the some of the minor modification in the tablet, and then again they go for patented product, and they will have the more than another 20 years protection, and they can enjoy the monopoly in the market. So because of this 3D section, actually it stops or it prevent evergreening of the owner. So to restrict the monopoly of pharmaceutical companies, they have introduced this section 3D in the act, and now pharmaceutical companies, they have actually think about it, and then they cannot actually have the patent for maybe 30 years, 40 years like that. Okay, because of this 3D section. And why it is important? Because see, the medicine should be available at reasonable cost to all the people. So that is the main motive behind having this 3D section. So this is just to give example. It's a patented technology. So grinded or of the mixer is patented. There are millions of patents registered in the world. If you just go, I will show you the sites also. So if you just go through the sites, you will find that there are millions of products, they are already registered and got the patent. So how we will get the patent in India and also in foreign countries, how to file a patent application, what are the different types of patent application, that we will see now. Now, what is the procedure? As I said, it's a very critical or complex process to file rather to get a grant of a patent. Just to file a patent application also, if you just see the format of the application, it is very, very important or crucial to draft the patent application. I will show you the draft of this and what are the sections you have to add in the patent application. So first step is you have to file the patent application in Indian Patent Office. Then whatever documents you have to attach, that will be checked by the office. Then, as I said, publication means what? The invention will be available or it is disclosed in the IP and on the IP India site. Okay, so whatever invention, whatever process or maybe the product for which the owner or creator wants grant of patent, that will be available on the IP India site, and then anybody can see it. The next step is request for examination. Then examiner will go through it. The examiner will check each and everything. That examiner has to check that whether it is previously patented, whether similar kind of invention is already patented, or they have to rigorously actually check or examine the patent application. Then first examination report is issued. Then whatever objections or maybe questions are raised by the examiner, they have to respond by the applicant. Then pre-grant opposition, as the application is available on the IP India site. So anybody can go through it and anybody can oppose it. So pre-grant opposition means what? Before granting the application, anybody can oppose it. And that this pre-grant opposition is not dealt in the court, actually. It is in the IP India office. It is filed, and then applicant has to satisfy this. Okay, applicant has to answer all the questions which are raised by this pre-grant opposition application. Then if it is everything is fine, it will go ahead, and then considering this pre-grant opposition, the patent is granted to the applicant, and then again also for 12 months it is open for the post-grant opposition. So anybody can oppose it. So that is also available for 12 months. And then if anybody, suppose anybody have filed this post-grant opposition, then it will go to the court, and then applicant has to prove that the invention is true and not belong to anybody. So these are the 11 steps actually to get a grant of patent in India. So in the pictorial form, I have just to make it easy, that file application. Complete specification is nothing but it's a patent application. It's a legal word actually. Complete specification means it's a complete patent application. Provisional specification means what? It's a, if invention is not complete, it is in the process, then it is known as a provisional specification. Specification, you can just remember that it's an application. So the same procedure just now, whatever I have explained, it is in the pictorial form. So FER, first examination report, is issued, and then I have mentioned here time duration also. So again, in the first month, examiner has to release the first examination report. So there is a restriction or time limit from both the sides, to IP India office also and to the applicant also. So both have to actually follow this, and then only the patent is granted to the applicant. Now, first step in the procedure is itself is a file the patent application. So now there are types of patent application. So just now we have just seen that different treaties we have discussed. So related to that also, I will explain it here. So provisional application or provisional specification, it is in the legal word, it is known as a specification. So provisional specification or application is nothing but if you are not quite ready with the invention, then the inventor can go for this application. Now, then what is the benefit of filing this provisional application is that, as I said, when the date at which the inventor is filing the application, then that date will be the grant of the patent. Means what? It is known as a prior date in the legal language. So suppose I have filed the patent provisional application, suppose today on the 5th March 2022, and I have got the patent in maybe after 2 years, but the patent is granted from 5th March 2022. So if you want to suppose get the time to work, and also you want to file it to protect it, otherwise anybody can actually use it. So if you want to protect your invention and still your invention is not quite ready, then in that case you can go for the provisional application. Okay, and to gain the time of 12 months, because if you file the provisional application, then within 12 months you have to go for the complete specification, that is complete application. Okay, so when the invention is fully ready or completely ready, then inventor can go for the filing the complete application, complete specification. Okay, so this is the two. Actually, if you want to gain the time, then inventor can go for the provisional application. If everything is ready, then inventor can file the complete application. Then this is just now we have discussed, it's a PCT, that is Patent Corporation Treaty, or under Paris Convention. So if any inventor wants to have the protection in other countries or in foreign countries, then that inventor should go for the PCT application. Okay, so whatever countries now 173 or today it's a 192. So all these, if the patent is granted, then in all these countries, the invention have the protection. So this is the important. Okay. So this is the PCT application. Then divisional application. So according to the section 16 of this IPA, you can divide the work and the application divided out of the first mentioned patent application. So you can have the division application, but the patent is granted only for the single invention. Then patent of addition. Suppose during the 12 months of the period, or maybe you have filed a complete specification or complete application, and then you want to add something, a particular time duration is given. And then in that time duration, you can have the patent of addition. Suppose inventor has done some improvement or modification in the invention, they can go for the patent of addition. Now, this is the format of patent application. Now, till this point, what we have discussed is the first step is the filing the patent application in Indian Patent Office. For that, these are the different types of patent application. Now, what is the format of patent application? It is also very important because everything will depend upon the application itself, whether you are getting the grant or no. That depends upon how you have drafted the patent application. So that is very, very important and also very complex. So these are the actually format of the patent application, in which title, field of invention, background of invention, then statement of objective of invention, brief summary, brief description if there are drawings, then detailed description, then claims. Claims are very important. To draft the claims is very complex, because on the claims the grant is given. So whatever claims you have mentioned in the patent application, based on that the patent grant is given to the applicant. So drafting of claims is very important. So this is the actually format of a patent application. As I said, if you want to go for the patent application in foreign countries, then through PCT, that is International Patent Application, you can file it. You have to file this PCT application in Indian Patent Office only. Actually, PCT application means at the PCT means what? Actually, it's under the Paris Convention, but that international treaty, they are not giving the grant of the patent. Our Indian Patent Office only giving the grant to the patent. So it is just a method of applying the patent application at international level. So PCT does not provide the grant of the patent. It's just a method of applying the patent in foreign countries. So the countries which have signed the Paris Convention, if the patent is granted, then it is protected in all these countries. So this is the, if any applicant wants to file the patent application in foreign countries, they should file it through PCT application. So these are just the durations are mentioned. Now recently these durations are actually revised by the Indian Patent Office, and now early publication, early examination facilities are also available. So the duration of granting the patent, they wanted to reduce it. So that's why these are revised by the Indian Patent Office now. So this is the publication and all these things I have mentioned just for your information. Now, if anybody wants to file the Indian Patent Office application, then this is the actually site. Okay, so IP India online.gov.in online. So you can go to the IP India office, and both the things, means in the physical format also it is allowed, and also in the online format is allowed. So recently from 2007 they have made this online also, so you can have the online application also. Then claim wise actually fees mentioned. So if you just wanted to know the fee structure, it is also available on the IP India office. I have not just mentioned the entire chart in the PPT, but you can go through the IP India site. And this question is a standard question, that how much fee is required. So it depends upon the lawyer, patent attorney, or maybe patent agent. So it is ranging from maybe 30, 70 or whatever it may be, according to that lawyer firm or attorney. So 3 to 6 years actually are required, but now government is trying to give the patent, granting the patent in maybe 2 years also. So recently some of the patent agents, they have tried actually hard, and they got the patent in 2 years also. So some of the cases I have seen in Pune also. So before filing patent application, inventor can search previous patent. Now this actually I have included because in the last session, some of the participants, they have asked about this, that whether my invention can be patented or no, means whether it is eligible for the patent or no. So how to check? So basically you can search the previous patents actually and confirm that whether similar invention is patented previously or no. So you can confirm it. How you can confirm it? How you can confirm it? So see, there are patent search free sites. Okay, so one of the site is the Google patent. I will just try to click it on if it is I will show you how to search it, though it will require this is the Google patent site. So if you just type it, recent patents, see, So if I just have typed general word, so if you want to search for a specific field patent, then you can type that specific words. So once you, the screen is visible to all of you? Ameya sir?
Yes, ma'am, the screen is visible, but your
yes.
PPT is visible actually.
Okay, so I just a minute.
You need to reshare your screen and select share entire screen.
Now is it visible?
Yeah.
Yeah. So see, this is a actually I have typed Google patent on the Google, so it goes to the Google patent site, and now on the I am on the Google patent here. You can just see here. So here you can just search the patent by date, by your maybe keywords, or maybe by any field. So each and everything is available. So I have typed just recent patent on the Google patent search. So here you can see the word recent patents. So it has shown the recent patent that are filed. Okay. So another I can just show you. Suppose patent scope. This is another site. Is it visible to all of you? Patent scope. I think it is visible. Yes. Okay. Yes. So here you can just see it is a free site. So you can search by your own whether your invention, you can file the patent application for it, because see, for filing the patent application, before that, because it will require time, it will require money, it will require patent agent or patent attorney or lawyer. So before that, if you just want to confirm that whether similar invention is patented or no, you can just do it searching by yourself. So access the patent scope database. So you can go inside. Just a minute. So now we are in the database of the patent scope, and here you can just see that, see here. So suppose it's a simple search. So you can type any related terms. Suppose touch screen. Suppose I have typed it as a touch screen. So the patent which are granted related to touch screen, it will show. So whatever invention you have, you can just type a related word in this. See, these are the, you can just see, these are the touch screen, or maybe the screen word is used. So these are the patents. See, a processing method and device for screen touch operations. This is filed in 2017. This is filed in the folding table touch screen mobile phone in 2011. It is filed. So all the list you can actually see. Okay. So I have just shown you how to go for the search. Actually, these are the free sites. So the USPTO, this is another United States Patent and Trademark Office. This is also free site. This Lens is also free site. It's an Australian non-profit organization. So you can search a similar invention on all these sites. Then, as I said, millions of patents are granted, and it is very, very huge database. And if you want to search it, you can search it by your own. But again, focus prior art search. That is, prior art means what? Whatever previously granted application. So if you want to do that, it is having a particular method actually. And according to the classification and all these things, you have to go for the search. These are some of the list of paid sites. So these are available with the patent agent or maybe patent attorney or lawyer. So just you can search it if you want on the free sites, and you can check whether similar invention is available or no. Then moving ahead, commercializing the patented product is very important because see, in the academics or in the teaching field, in the education field, most of the teachers, they are actually nowadays, from last maybe 3, 4 or 5 years, teachers are trying to file the patent application. Some of the teachers, they are getting the grant of the patent also, but now they are not doing anything with that invention. So it should not happen, because commercializing the patented product is also very, very important. So if suppose you don't have sufficient money with you to go for the production of it, so you can have the licensing. So this is the one of the provision which is given in the section 48 of this IPA. So to raise the finances, you can assign the licensee, and that person, it's again written agreement, you must know about this. So that person actually invest amount in that, and you can have a written agreement, and your invention can be converted into the product, and that product will be available to the society. So there are 2-3 benefits, that the genuine product will be available to the society, and also the patentee or the inventor can have the financial benefit of it. So this licensing is a very important and plays a vital role in the technology commercialization. So now this you must have observed in 2020 actually. So in the second wave of this COVID-19, and the Delhi court actually had suggested the government to implement the compulsory licensing. This is also one of the provision mentioned in the act, and they have given compulsory licensing to the pharma companies so that the vaccine will be available to all the people. So that's why today more than 100 crores people, they are vaccinated, and now India is in a quite a better position and compared with the other countries. So just to give a scenario of this patent application, so you can just see here in 2017 13,045 actually patents were granted in India. So twice as many as 2015. So as I said, now it is IPR and IP importance. IP is known to people now, and now they are trying to file the patent applications, and they are trying to protect their IP. So this is one of the actually graph we are showing here. So this is the intent patent. So here you can just see means all the IITs, TCS, Bharat, BHEL also means they are filing the patent application for their inventions. And these are the top US patents granted. So you can just see IPL, this IBM, Apple, then Samsung. As I said, mobile is all the parts of the mobile of all the companies, they are protected. So this is another, just to give you or summarize this, that 5,000 IoT patents actually filed in last 5 years, and around 60% of patents were filed by electronic manufacturers and 13% by IT companies. And most important is that 40% filed patent have been granted. That is very, very important. So most of the patents now are getting the grant. So these are the latest figure actually. So if you just see, these are available on the Google also actually. So from just a span of 9 months period, from April 1 to December 31st, 2020, these many 43,028 patents application were filed during this time period. And again, most of these are actually granted, and that's why this International Intellectual Property Index released by this US chamber, now India has ranked to 40, so highlighting tangible improvement in its IP ecosystem. So now people are understood the importance of this filing or registering this IP, and they are going for this registrations, and they are protecting their IP. So this is just to give the summary in a brief. So these are the maximum year of protection, renewal. And as I said, after 20 years, the patent, whatever invention is patented, that will be available publicly. So these are the actually, just to give the summarized durations of all the types of patents. And these are the offices where actually you can file the patent or maybe copyright or maybe trademark or maybe GI. So these are the offices located in all these locations of India. So coming to the last part of this session, so we have discussed about the Patent Act. I have not actually elaborated the entire act. I have just focused on the procedures of getting the patent in India and abroad. and the patent application. So I have not gone through the detail of the drafting the patent application, because it is another session actually to draft the patent application. So how to draft, what are the maximum limits for the words in the abstract, or maybe the other things. So I have not gone to the detail of it, but we have discussed in brief about it. And there is a need to file a patent to protect an innovative ideas, invention, and to enjoy the financial benefit of it. So actually these are the articles which are available freely on the Google. So all are related with the actually patenting, patents, getting patent, imperative tips for patent drafting, patent licensing also. So you can go through it if you want. So that's all from my side, and thank you once again for your patient listening, and I will be happy to answer the questions now.
Hello, ma'am.
Yes.
Thank you so much for the session.
Yes.
Let me welcome our Honorable Vice Chancellor of Central University of Haryana. I request Sunita ma'am to please initiate with the formal welcome of our Honorable Vice Chancellor. Sunita ma'am. Sunita ma'am, please can you unmute yourself and check if I am audible to you? I think there is some technical issue at ma'am's end. Honorable Vice Chancellor, I wholeheartedly welcome you on behalf of Central University of Haryana as well as SkillSlate. I am really happy to have you again, and for this opportunity to be interacting with you again. I still remember our last program on mental health, and still people they refer to that program and the quality of content which was delivered from that particular conference to the people. So it has always been a wonderful associating with Central University of Haryana, and we are really grateful for your time, sir. I request you to please address and motivate our audience. I am happy to share with you that we have received more than 800 registrations for this particular workshop, and 50% of this participants are students, while 50% of them are HODs, associate professors, principal, vice principals, trainers, entrepreneurs, as well as training and placement officers. So I think the reach has been far and wide, and they all are eager to hear to your address, sir. Thank you so much.
I think sir is on mute.
Sir, please can you try to unmute?
Yeah, now it's okay.
Yeah. Good
Yeah,
afternoon, sir.
now it's okay. Yeah, it's thank you very much. Yeah, I'm sorry because I could not join you in the beginning. I really thought that I should attend this because it is also very important for, I will say for the, even for the vice chancellor or the principal or the administrator of the institution to know what are the, IPR and what are the present rules available and what the employees has to do, what employer has to do. So these are the important thing. So I was just listening to the last part of the talk, Dr. Jayashri's talk. I really felt that I have missed something. But it's a very important exercise which is being carried out by joining these two institutions. For the participant, as you said, there are more than 800 participants. I can still see a lot of participants even at present through the Zoom mode. Also, you may be doing it through the other modes. I can also see my Dean of Academic Affairs and some of my colleagues. And I can understand that this is a very important aspect because nowadays we not only just look for the publications, and the publications are important, but we also look for the patents, and especially when we are going for, the self-reliance India, and that we have realized, within the last 3 to 3 years, I will say just 2 years, maybe we have realized what has happened around this, around us, I will say through the whole of the world, or even otherwise what is happening even on today. So you can understand if we have the sanctions on one country, it affects maybe all other countries who have injection nodes to them, right? So that means the only thing is that we should have the self-reliance, and if they have the self-reliance, obviously we have to do research, or we have to innovate in such a way that we can translate into the business. So that is where we were lacking, and we are progressing, and we are in the right direction now. And at the same time, it is very important that our faculty and the faculty of the institutes understand it. And once they understand, they will realize that maybe the filing IPR, once you have done some research, maybe should become easier than publishing a research paper. Even for the publishing research paper, you have to now carry out the plagiarism check, and you have to have a good English, and so many things are there that you learn during the PhD. But such things were not part of our PhD programs, and now you're doing this, and I really congratulate all of you for attending it and for making it possible. And we have the good speakers, and I think it is a 2-day workshop, and I think that tomorrow our participants will be also benefited out of this. So I just wanted to say best of luck, and thank you very much for organizing this talk. I hope that definitely some of us will be benefited out of it. Thank you very much.
Thank you, sir. Thank you for joining us, even though you are very busy with your prior task. So thanks a lot for joining us, and thanks for your motivating word. No doubt the workshop is very informative, and most of departmental heads, faculty members, student all over the other institutes from north to south have joined this workshop. And today it is discussed in length by Dr. Jayashree on the patent, what is patent, treaties and all. And tomorrow in depth, she'll talk about the copyright and patenting. So thank you, sir. Thank you for motivating us.
Thank you, Sunita, for organizing such a.
Thank you, sir. Thank you. Your blessings are always there, sir.
Next photograph. Can everyone please turn on their videos quick?
Ameya, sir, before we proceed to the photograph, I would like to invite Dr. Nishant Singh, sir, for formal vote of thanks.
Please.
Or shall we go for the photograph first?
If sir is available, it depends on
So we'll go for the photograph first, no issue. My camera is not working as usual.
Just quickly turn on your cameras.
Yeah. No ways. You proceed. Please proceed.
Just a second. Where are you?
So actually, it's not working, so it's okay.
Yeah. Smile, everyone. All right. Thank you so much, all. Thank you so much. Thank you, Honorable Vice Chancellor, for your precious time and guiding all the participants. And I really would like to appreciate Sunita Kanwar ma'am's effort in making this program a great success and reaching so many people. Thank you so much. Thanks a lot.
Thank you.
Sir.
So Can I request the participants, if they have any questions, they can
Yeah.
ask from Jayashree ma'am, and then we'll proceed to vote of thanks.
Yeah. So
Participants, if
actually,
you would like to share your experience, please feel free to unmute yourself.
Dr. Shilpa, I will just explain this in tomorrow's session. In the field of management, what you can do. So I will explain it tomorrow's session. We have a session on the copyright tomorrow. So can you repeat the slide of patent agent? So patent agent means exactly what you want to ask. Miss Roy.
Okay. Ma'am, I think we should move towards the formal vote of thanks. After that, if anyone would like to share their experience, they might share.
Okay. Thank you, Jayashree ma'am, for such an informative session, and I hope each one of the participants will be benefited out of it. And definitely would like to conduct more sessions of this type, and would like to invite you for all those sort of things. So thanks a lot, ma'am. And now I'd like to request Dr. Nishant Singh for the formal vote of thanks. Dr. Nishant Singh. Maybe Nishant sir, is it audible? Okay, I think somehow maybe he's not possible to connect. So in any case, I'll proceed with the formal vote of thanks. So
Ma'am, I'm audible?
Yeah, sir, please. Dr. Nishant, please.
Yeah, ma'am. Good afternoon to all. Thank you so much. I deem it a great honor and privilege to propose the vote of thanks on this memorable workshop. Let me first of all thank you so much our Chief Patro, Professor Tankeshwar Kumar ji, Vice Chancellor, Central University of Haryana. Then we are grateful to our, thank you so much, ma'am, for nice session. Encourage. I thank our Sunita ma'am, coordinator, convener today workshop. And then secondly, coordinator Sunita, Tawar ma'am, thank you so much. And then thank you, Central University of Haryana, all staff and teacher. My heartfelt thank to the all HODs, faculties for their valuable contribution, guidance and encouragement of all efforts. Gratitude to the non-teaching staff, and then all work hard to ensure that this occasion become a memorable success. I thank all these distinguished invitees present here, accepted our invitation. I thank the member of the media of ensuing interested in conveying the event of all goods heart. We work behind the screen. Last but not the least, I thank you, my friends, for your cooperation in making this function a resounding success. Thank you so much. Once again, I thank you all for your attention. Thank you so much.
Thank you, Nishant Singh sir. Thanks to all the faculty members and Mr. Ameya Agrawal to make this event very fruitful. Now I'd like to hand over the mic to Ameya sir.
Thank you so much, ma'am. Thank you so much. Guys, if any one of you want to share your experience or talk with the speakers or anyone here, we can have a 5-minute session for networking. Please feel free to unmute yourself and turn on your videos, and you can talk about this particular workshop or just anything you can share about yourself as well. So we do this to make sure that every one of our participants, they connect with each other and they learn from each other, and it creates a strong bonding. So please feel free, don't hesitate. You can raise your hand and I can unmute you. If anyone would like to share, please do share. I think this cohort is a little shy as compared to our other cohorts. People are usually very excited to share their experiences or talk to the guest. Guys, don't lose this opportunity, actually. Trust me.
Hello, hi. Am I audible?
Yes, Sakshi, you are very much audible.
Yeah. So actually, I just wanted to share a few things regarding my business, and I also wanted to interact regarding that, ask few questions. So basically, my business, I have already launched it. It is a social media based business where we'll be, selling the products to the customers. Where if you have any product that is, it can be anything. Should not be an inventory or anything. If you have any kind of product ranging from a small, a piece of painting to, farm products, all of those we are planning to sell locally, on a local basis, not on a pan-India level. So whatever products they have. So I just wanted to know if someone is there in this group who has some product, who has like they are making.
Thanks a lot. But when we mean to share anything, it's not about promotion. But if you'd like to know anything about the IPRs or copyrights related to your
Yes.
ask Jayashree ma'am. Yeah?
Okay, sure. I would like to ask ma'am a question. Do I need to register a patent? Like there is no patent for this, right? So I suppose I'm using social media to buy and sell things. So patent is not required in this, right? Ma'am?
No, patent is not required for such cases. So you are using it for your business. So it's okay. So this is not actually new idea actually. So you can go through it without patenting, because many people are actually similar kind of thing they are doing. So it is not eligible for the patent actually.
And those businesses which are in contact with me, which are selling, suppose a business which sells bangles. So they are making bangles from Firozabad. So that is something that is not everyone is doing from that particular place. So is that also like those people who are getting in contact with me, those sellers? So unka patent will not.
No. Actually, if you are talking about the bangles, then it can go under industrial design, because it under the 2D or 3D thing, isn't it? So you can think about industrial design for that actually. But there should be something new in that bangles, and you have to prove that. Then only it will be granted to you. But patent is not for that bangle. You can go for the industrial design in that case.
Got it.
Yeah.
Okay. Thank you, ma'am.
What was your experience, if you can share in 1 or 2 lines?
Ameya sir, I just want to say something. Maybe the participant, after going through today's session, they may come with more questions for tomorrow's session. The reason being, today they are much aware about the concept of patent and for different things for which they go for. So maybe by tomorrow they will come prepared with more of the inputs and the queries, that how they can go on filing a patent, what could be the procedure form, if they're facing any problem, they would have checked it. So in any case, if you have any other questions or want something to be add on for the tomorrow section, kindly let us know.
Yeah. That's a good point actually. If guys, if you would like to add us something for tomorrow's session, please let us know. So we can request Jayashree ma'am to add that particularly for tomorrow's session. So you can let us know that as well.
Yeah.
Please.
So I will just brief. Tomorrow, the first session will be on the copyright, and the second session will be on the importance or IPR role in academics, in research. And as many students have joined the workshop, so I will explain the career opportunity in the IPR. So other than this, if you want to add something, please let me know.
Ma'am, Dr. Usha Nagarjan has mentioned that if you can add more case studies for better understanding and clarifications.
Yes, sure. In tomorrow's session, in the first session, I have added copyright cases actually.
Yeah, that would be better, ma'am. Yeah, that would actually make people to be more interactive, I feel. So,
yes. Sure.
Thank you so much. Thank you so much, Dr. Usha.
Welcome.
Prakash Ojaji, do you want to say, share something? Rakesh Ojaji.
Yes, sir.
Yeah, would you like to
Hello.
share something?
Okay. Okay, sir.
Thank you so much, all. I think we can mark this session, today's session as completed, and see you all tomorrow, same time at 11 a.m. Please, also in the meantime, if you would like to add something for tomorrow's session, do let us know faster so we can request ma'am to inculcate those in tomorrow's session. And Dr. Neha is asking from where we can search for international patents. So,
Patent Scope and Google Patent. These two sites are actually good for to
if
search for
possible,
international.
can you share a short document with all the important links so we can circulate it with
Yes, yes.
the participants? Yeah. Yes. Thank you so much, ma'am. Thank you so much. Thank you all the participants. It was really a pleasure to have you all. Thank you to all those who have joined us on the YouTube as well. It was great having you all. I think we missed some of the questions from the YouTube, but no worries. Due to time constraint, we have to wrap it up. But tomorrow we are going to take most of the questions if the time permits, and we will make sure that all your queries are answered. Thank you so much, all. It means a lot. See you soon tomorrow. You can still share about the workshop with your faculty members and students. It is open for all. Thank you so much, all. Thank you.
Thank you. Thank you, Ameya, sir.
Thank you.
Guys, feedback link will be shared on the WhatsApp group and on the email. So please do share your feedback for today as well and tomorrow as well. There will be 2 feedback links for today and tomorrow. All right. It will be shared in the WhatsApp group shortly.